All right.
President and judges of the Caribbean Court of Justice.
Please take your seats. Caribbean Court of Justice Appellate Jurisdiction, CCJ application number GYCR2018 between Mark Fraser versus the state for the delivery of the reserved judgment this morning. Can we have the appearances for the court, please? Thank you.
May it please your honors, Kamal Ranford, applicant who is present in court today.
May it please your honors, Shalimar Alihat, Director of Public Prosecutions for the state, together with Mrs. Diana O'Brien, Assistant DPP, and Mrs. Kishana Lake, Assistant DPP. Thank you.
Thank you, and good morning, Council. The judgment in this matter was a unanimous one. It was concurred in by Mr. Justice Barrow as well, although he's not here, and it is being delivered by Mr. Justice Jamadar, and so I will invite him to read a summary of the judgment.
Good morning, everyone. First of all, this summary is not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. Mark Fraser, a former member of the Guyana Defense Force, was found guilty of gross negligence manslaughter on the 14th of November 2007. He was sentenced to 4 years imprisonment. Fraser filed an appeal against his conviction and sentence on the 14th of December 2007, and he obtained bail pending appeal on the 17th of December 2007. Fraser received no information about his appeal until July 2017, when he was informed by his attorney that his appeal had been fixed for hearing on the 24th of July 2017. This hearing was adjourned twice. First, to 5th of October 2017, because neither side had been provided with a copy of the record of appeal, and then on the 5th of October 2017, because Fraser's attorney was only served with the record the day before. At the hearing on the 5th of October, Fraser's attorney raised a preliminary point. He claimed that Fraser's right to a fair hearing within a reasonable time, as guaranteed by Article 1441 of the Guyana Constitution, had been breached by the delay from the time of filing of his appeal to the availability of the record of appeal and the listing of the appeal, and that this unfairly impacted his ability to conduct his appeal. The Court of Appeal decided to hear the preliminary point and the substantive appeal together on the 16th of November 2017. But Fraser applied to the CCJ on the 6th of November 2017 to challenge that decision. That challenge failed, but the hearing of the appeal before the Court of Appeal was again adjourned, this time to the 25th of January 2018, and then one final time to the 5th of March 2018. On the 8th of June 2018, the Court of Appeal dismissed his substantive appeal, but agreed that the delay breached his Article 1441 rights and stayed any further imprisonment. Fraser's application for leave to appeal to the CCJ pursuant to Section 6 of the Caribbean Court of Justice Act was refused by the Court of Appeal on the 1st of November 2018. So he then sought special leave from this court to appeal the refusal of the Court of Appeal to set aside his conviction. Fraser argued that special leave ought to be granted because the Court of Appeal's decision was flawed in 3 ways. First, they erred in refusing to separate the constitutional delay arguments from the substantive ones and to hear and determine those first. Second, they failed to set aside the conviction on the constitutional delay arguments. Third, they failed to set aside the conviction on the merits of the substantive appeal alone or taken together with the constitutional delay arguments. He also suggested that the failure of the Court of Appeal to grant him leave to appeal as of right to this court justified the grant of special leave in this case. The court found that, despite the raising of a constitutional issue, this remains a criminal appeal. And the relevant test for the granting of special leave is that stated in cases such as Cadogan versus the Queen per Hayton JCCJ and Doyle versus the Queen per Nelson JCCJ. That is, whether A, there is a realistic possibility that a potentially serious miscarriage of justice may have occurred, and or B, a point of law of general importance is raised that is genuinely disputable, and the court is persuaded that if it is not determined, a questionable precedent might remain on the record. The standard to be met to satisfy this test is that of arguability. The court found that the approach of the Court of Appeal in hearing the constitutional delay challenge and the substantive appeal together to be wise and prudent, as it allowed the Court of Appeal to properly consider what might be a just and effective remedy for the breach of Fraser's Article 1441 right. Having found merit in the constitutional delay point, the Court of Appeal then granted what it considered to be just and effective relief. No prejudice has thus been demonstrated, and no serious miscarriage of justice can therefore realistically be argued to have occurred. In respect of his claim that his conviction should be set aside as a result of the delay, the court itself has made it abundantly clear in the cases of Singh versus Harry Chan and Brijlal versus Hari Prasad that, while a conviction may be vacated for violation of the constitutional right to a fair trial within a reasonable time, only in special or exceptional circumstances will post-conviction delay result in the setting aside of a conviction properly arrived at. This is partly because courts in such cases must balance the principle that persons properly convicted of crime should serve legitimate sentences against the fashioning of a remedy that is just, effective, and proportionate where a fundamental right has been breached. The Court of Appeal considered all of this and concluded that the conviction was sound and that no special or exceptional circumstances were established to justify vacating the conviction. This court found no flaws in the approach or reasoning of the Court of Appeal to conclude that its decision and reasoning have resulted in any serious miscarriage of justice being suffered by Fraser by reason of post-conviction delay. In addressing the soundness of the conviction, the court found the trial to have been unremarkably straightforward. As the court noted, the Court of Appeal said that, quote, the respective cases for the prosecution and the defense admit of no complexity. The simple and agreed facts of the case are that Rollins was shot by Fraser, and as a result of that shooting, Rollins died. Majority of the jury, having duly considered all the evidence, the addresses, and the trial judge's summation, agreed with the prosecution. Fraser contended that the verdict was unsafe because of a plethora of procedural errors made by the trial judge in the conduct of the trial, his summing up, and even his post-summation directions to the jury. The court found, however, that the thresholds have not been met in relation to the grounds advanced in challenging the soundness of the conviction. On the applicant's contention that special leave ought to be granted on the basis of the Court of Appeal's refusal to grant leave to appeal as of right, the court indicated that even if an applicant had been wrongly refused leave to appeal as of right, this court still needs to satisfy itself that the test for obtaining special leave has been met. The court found that the Court of Appeal did grant redress to Fraser for the breach of his Article 1441 rights, and did so in circumstances in which the constitutional challenge could not have arisen before the trial court. No reasons were given for the Court of Appeal's refusal to grant leave, and though the correctness of that ruling may raise questions of law of general importance, the court was not persuaded that its exploration warrants the grant of special leave in this case. The court said not only is the grant of special leave discretionary, but the court special leave application exists independently of whether the applicant has had an appeal as of right or has sought and been refused leave from the Court of Appeal to appeal to the CCJ. Finally, the court referenced two policy principles to which it adheres in applications for special leave in criminal cases. First, the court will not lightly interfere with findings of fact implicit in the verdict of the jury or those made by the court from which the appeal originates. And second, where the Court of Appeal exercises a discretion and sets out the grounds for the exercise of that discretion, the court will not review it unless the grounds relied on cannot support the conclusion reached. In this case, the court found both of those to be resolved in favor of refusing special leave. The jury, as primary finders of fact, decided that Fraser was guilty of gross negligent manslaughter. The trial judge, after considering a social services report, imposed a 4-year custodial sentence. The Court of Appeal agreed with the soundness of these conclusions. This court is not to lightly interfere. Likewise, the Court of Appeal's decision not set aside the conviction and to stay further imprisonment was well within the legitimate range of options open to the Court of Appeal. And there was no flaw in their reasoning and no fundamental unfairness, unreasonableness, or injustice in the outcome. In all of these circumstances, no realistic possibility exists that a potentially serious miscarriage of justice can be said to have occurred. There is therefore no proper basis on which to grant special leave to Fraser, and his application is therefore dismissed.
Yes. Thank you, Mr. Justice Jamada. Before we rise, I wish to make a brief statement. It has been a long tradition I would just ask your forbearance for 1 minute. And this is because we are being joined by a number of staff members of the CCJ in connection with the remarks that I wish now to make. I was saying that it has been a long tradition that our court proceedings would commence after a discreet exchange of nods between the presiding judge and Mr. Nandlal Hadiar, our trustee registry supervisor. Sadly, earlier today would be the last occasion that this little private rite would be observed, because today is Mr. Hadiar's last day at work. Today we mark his retirement. Today also marks the last day of one of our excellent judicial counsel, Ms. Tanya Alexis. But even as we will all miss Tanya, who was with us for 3 years, I think that even she will agree that the day really belongs to Mr. Hadiar, who is actually one of the longest serving members of staff at the Caribbean Court of Justice. Among the lawyers who file cases in this court, Mr. Hadiar is without doubt the best known member of staff. It is difficult to conceive of a more experienced court registry official anywhere in the English-speaking Caribbean. He has been involved in the processing and management of cases filed in a court of law from as early as 1974, when he was a clerk employed at the High Court of Justice in Trinidad and Tobago. His consummate professionalism, his appetite for work, saw him rise steadily through the ranks so that by 2004, he was the section manager and second deputy marshal of the Trinidad and Tobago Judiciary, where he was placed in overall charge of the smooth functioning of the administrative side of the Court of Appeal of that country. Throughout the course of this period of his work life, Mr. Hardiel made sure to attain formal qualifications to enhance his undertaking of the responsibilities that came with his job. He obtained certificates in basic and advanced paralegal courses, and he successfully completed courses in delivering service excellence, change management, computer repairs, and court performance standards. When in 2005, the newly minted CCJ was advertising for the post of registry supervisor, Mr. Hardiel was a natural fit. No one could compete with his credentials. He was appointed to the position on the 22nd of December 2005, and since then, he has been an integral part of the court. Earlier, I indicated that he was the best-known member of staff among the lawyers who filed cases at the CCJ. And this is because during his time at the court, more than anyone else, it is he who has been instrumental in liaising with counsel on their cases, providing guidance to them, and serving as a helpful bridge between the attorneys and the registry and the attorneys and the court. But even beyond this, Mr. Hardiel has been pivotal in shepherding both the court and counsel throughout the region in the use of the advanced court technology employed by the CCJ. When my predecessor, Sir Dennis Byron, conceived the idea of the CCJ being the first court in the English-speaking Caribbean to facilitate e-filing, Mr. Hardiel was placed in charge of that project. It was a huge project because the software to enable it was simultaneously being developed by the court. Mr. Hardiel played a huge and important role in both the development of that software and in its implementation. Thanks to him, that project proceeded seamlessly and was an overwhelming success. E-filing at the CCJ through the courier software owned by Apex is now a natural part of this court's operations, and Mr. Hardiel is the region's authority on e-filing using the courier suite. In this capacity, he has delivered presentations on the subject throughout the Caribbean, demonstrating its benefits and encouraging other judiciaries to embrace the technology. I well recall the visit of a foreign judiciary delegation to the CCJ earlier this year. Mr. Hardiel was so impressive in his presentation that the visiting Chief Justice was overwhelmed with his breadth of knowledge and expertise. This court will sorely miss you, Nanlal. On behalf of my colleagues and all the staff of the court, I express deep thanks to you for your many years of service to the court and the region, and we wish you a happy retirement. I also would like to thank Mrs. Hardiel for sharing you with us over the last 14 years. Justices Rajnath, Barrow, and Burgess, who unfortunately could not be here today, have specifically asked me to indicate their endorsement of all the sentiments I have expressed. Thank you.
May I please honor the Chief of the Court on behalf of the State of Guyana and the lawyers of the Guyana Bar. I wish to also convey my sincere thanks to Mr. Hardiel for the support, the assistance, and the courtesies he has extended to all lawyers in Guyana. We wish him well. We wish him good health. We wish him a happy retirement with his dear wife, Mrs. Hardiel. And I'd like to take this opportunity to also welcome Mrs. Daya Thompson and tell her we look forward to working with her, as was mentioned by Mr. Hardiel in his letter to us. Thank you, please, Your Honors.
Thank you very much, ma'am.
With Your Honor's leave, I'd like to echo the court sentiments and those of the DPP. I've worked over many years with Mr. Hardial, and I don't know who I'm going to call now to get the kind of help that he has given. Thank you, Your Honor.
Thank you, Mr. Ramkar.
Yes.
Well, guys,